Dr. Dina Zuvala. I'm an associate professor at the UNSW College of Law, and I'm organizing this seminar series, which, as you know, is entitled The Politics of International Law, that is hosted by the college and sponsored by the Center for International and Public Law. Before I proceed any further, I would like to acknowledge that usually I'm at the ANU, but currently I'm in Sydney on the lands of the Gadigal people of the Eora Nation. I would like to pay my respects to their elders, past, present, and to come. And I would like to acknowledge that sovereignty over these lands was never ceded lawfully. This was and remains Aboriginal land. Today, I'm very much excited to be welcoming Dr. Noam Peleg. Dr. Peleg is a senior lecturer at the Faculty of Law of the University of New South Wales. He works on international children's rights law, and he brings into the conversation human rights law, childhood studies, and family law. He has published widely on these topics in leading journals and edited volumes, and he has also published his own very important monograph entitled The Child's Right to Development, which was published by Cambridge University Press in 2019. In addition to all that, Noam is the book review editor and member of the editorial board of the International Journal of Children's Rights, and he's also co-editor of the Current Perspective section at the Australian Journal of Human Rights. And before his academic work, Noam practiced law in a number of human rights NGOs, especially specializing in representing children in courts. Noam will be in conversation with our very own Dr. Anne McDuff. Anne is a senior lecturer here at the ANU College of Law. Her work focuses on a range of critical theories, including feminist, postcolonial, and queer theories. And Anne's work examines how law, but also law teaching of law, devalues difference. And she's particularly interested, also drawing from her doctoral studies in Australian citizenship law, in the ways in which it looks, neutral and inclusive, but is anything but. Anne also is a fantastic teacher. She has received the 2015 College of Law Education Award for Teaching Excellence. And one of the things she teaches at great success and is one of our most, I think, popular electives is family law, right? Which is why I thought this would be an interesting pairing in discussing Noam's paper. Noam and Anne have agreed on a more conversation-based structure for this talk. Noam will offer some introductory comments. He will hand off to Anne, and then he will continue with some further comments. We are hoping to have time for questions from the audience, so please use the chat function to write your comments or your questions, or after Noam and Anne are done, please raise your hands. Without further ado, I'm going to hand over to Dr. Noam Peleg, who is going to discuss centering child development in international children's rights law. Noam, thank you very much for joining us.
Dina, thank you very much for this invitation. And thank you everyone for joining us. And thank you, Anne, for agreeing to listen to me talking yesterday and for coming today to make some comments about what I have, what I will say about child rights and child development. I'm really grateful to be part of this wonderful series that Dina is convening. And let me first start my talk by acknowledging the Aboriginal people of the Eora Nation over UNSW campus, from where I'm joining you today, stands upon, and to extend my respect to an Aboriginal person who is here with us today, and to the elderly, past, present, and emerging, or anyone who is viewing this recording later today. And as Dina was saying, so acknowledge that their sovereignty over this land was never ceded. I have some slides that I would like to use because they include some quotes which might be easier for everyone to see other than me speaking about them. But the conversation today is a long it's part of a lifelong project that I'm engaging. I didn't mention that I published a monograph about the child right to development some 3 years ago. I was exhausted from this topic afterwards, but then I found myself continuing to work on child development and child rights even further. Now trying to see how the two issues combine between my two interests, international child rights law and family law. So this work is very much ongoing, and I'll be grateful for any insights, but also for the insights of all of you as I move further with this, developing this idea a bit more. But what do I mean when I say about this idea? So what I'm trying to look at is about three issues. It's about children and how they figure and how childhood figures in international child rights law, mainly the UN Convention, under the UN Convention on the Rights of the Child. And more specifically, why do we have such a broad protection for child development in international child rights law? And what does it mean for children to have their right to development protected under international law? Something which we as adults don't have. The UN Convention on the Rights of the Child is the most ratified UN rights treaty of all. All countries of the world have signed and ratified this convention besides the United States, while the other UN rights treaties that we have less intake. So in that sense, the UN Convention on the Rights of the Child that was signed adopted in 1989 by the General Assembly, adopted and ratified in Australia shortly after in 1990, represents it's somewhat universal law about children, representing, if you would like, an acceptance. This is a set of definite rights that children everywhere should have, and it includes, as I'm going to argue in a second, it also includes a unique protection for the right to development of children. And if you look at other international human rights law treaties, you don't see a similar right protected for adults. We have the 1986 Declaration on the Right to Development. It was reaffirmed in the 1993 Vienna Declaration, but those are not binding treaties. They are declaration in international law, they have their own standing, but they are not enforceable as much as international human rights law is enforceable, but we might leave that question to the end. And I'm going to give some overview about the history of international child rights law, because the 1989 convention was adopted against a century-long history of international child rights law, and the broad protection that for child development, which is embedded in that convention, was developed and built upon a history of protecting and centering child development in international child rights law. But the more interesting question is what kind of configuration of the child, the image of the child that the convention embraces, and what understanding of child development does the convention embrace, and taking these two together, what did it say about the need to protect the right to development of children, why we protect it, but more importantly, what it may mean for children in practice. And I hope to be able to give some suggestions as to what does it mean for children in practice to have their right to development protected. So going back to 1924, when the League of Nations adopted the first international human rights treaty that speaks about, my Zoom is about to crash, that speaks about international child rights law, one of the very few human rights documents adopted by the League of Nations. It is a short document, includes 5 principles, but we see that the first principle, the declaration from 1924 speaks about the child must be given the means requisite for its normal development, both materially and spiritually. Adopted against the implications of the First World War on children during the war itself and the famine across Europe that spread across Europe after the First World War, and its disproportionate effect on children. Children were dying from hunger, from preventable diseases, lost their parents, either their fathers who fought in the war, or both of them, they had to flee countries, were refugees. So it came to the realization that adults made war has a devastating impact on children. And the declaration from 1924 tries to tackle some of the most profound impact that the war had on children. And therefore, Principle 1 speaks about the fact that children must be given the means for their normal development, both materially and spiritually. And here we see the birthright, if you would like, of the protection of the right to development of children in international child rights law. It qualifies what source of development is protected. It is normal development. Maybe there are other features or forms of development that we might think about. And it breaks down development into two separate components. There is material development and there is spiritual spiritual development, two different aspects of development, of child development that one needs to pay attention to and to protect, right? It's a human rights mechanism. In 1959, we see the then newly established UN, the General Assembly, adopts another declaration on the right of the child in 1959, a decade after adopting the Universal Declaration of Human Rights, which is silent about children by and large, and when the negotiation about the two, what eventually became the 266 covenants began. So at that moment, building upon the 1924 declaration, the UN adopts a longer, more substantiated declaration about the rights of children. It includes 10 principles. And as you can see in these slides, that 5 out of those 10 principles, child development is mentioned. And the 1959 declaration tells us that children should enjoy special protections, mimicking the understanding of children as vulnerable beings who requires adult protection, and they should be given the opportunities by law and other means to enable them to develop physically, mentally, morally, spiritually, and socially in a healthy and normal way. So we see how the minimal definition that we saw in Principle 1 in 1925 has expanded. And now we have more domains of child development stipulated by the 59 declaration, and the qualification is different. Previously, we spoke about normal development in 1924. Now we speak about healthy development and normal development, saying something about the process of development and its outcome. And we have different domains of development that one needs to pay attention to: physical development, mental development, moral development, spiritual development, and social development. A much broader understanding of child development and more concrete ones comparing to what we had before. Principle 4 continues that and suggests that in the context of the child rights to social security, that right is there in order to enable the child to grow and to develop in a healthy way. And you can see how the language that Principle 6, 7, and 9 speaks about. And here we start getting a sense of how the child is understood in international child rights law. The child is this vulnerable person who should receive support and protection so they can transition into adulthood in a normal and a healthy way. So it's about the end product that we are looking for, to making sure that the child fully develops and become the person that he or she are supposed to become. And development is breaking down into different understanding and domains of development: spiritual development, mental development, and so on and so forth. We are less concerned, or international human rights law at that stage is less concerned with the child as a being, with the course of childhood, with the intrinsic meaning of childhood, if we can agree on any intrinsic meaning for that period of time, and it focuses on the endpoint. And that mimics the understanding of children and of childhood as a human becomings, as human in transition, as humans in the making. As Onura O'Neill famously said, that children's only remedy is to grow up. This is what children should be doing, that they should become adults. That's their mission in life. And international law, it seems, embraces this model at this point and provides the framework that supports children in that journey. Very little attention is given to either children's agency, to their own preferences about their own development, and to the importance of their life at the present. The 1989 Convention on the Rights of the Child embraces this perception of the child. That's what I argue. This is my reading of the convention. And it expands the protection for this image of the child. And it does so in a very interesting way. First and foremost, in Article 6.2, it recognizes for the first time the independent and unique right of children to develop in conjunction of the right to survival and the right to development, the right to life, the two other rights Article 6 of the Convention protects. And then it goes on in 5 other articles to expand on specific domains and specific qualifications of child development that should be protected in the context of specific rights of the child. So if we speak about the right of the disabled child in Article 23, there is a protection for the individual development of children with disabilities, which includes their cultural and spiritual development as well. In the context of establishing specific duties for parents, which is a unique feature in and of itself, but Article 18 suggests that parents have the duty and the responsibility for the upbringing and development of children. So the convention tells parents that their job in life is to make sure that their children transition into adults, confining parental duties and parental responsibilities into ensuring that the child is making through their journey in life. Article 27, which looks at the right to an adequate standard of living, subjugate these rights, or let me rephrase it, provides an objective for the protection of the right to an adequate standard of living. So while general international human rights law speaks about the right to an adequate standard of living in general terms, here we have an objective set for that right. The right of a child to a standard of living is in order to support their physical, mental, spiritual, moral, and social development. That's the end game. This is why we are protecting the right to an adequate standard of living. Article 29, one of the two articles that speaks about the right to education, suggests that education, the first objective of education, according to Article 29(1)(a), is to develop the child's personality, talent, and mental and physical abilities to their fullest potential. And here we see a different qualification of the objective. It no longer speaks about development in more abstract terms like healthy development or normal development. We have a more specific target here, which is to enable children to grow up to their fullest potential. It's more than just becoming an adult. It's what sort of adult the educational process should enable the child to become. And then in Article 32, which prohibits certain elements of child labor, there is a justification. And the justification for prohibiting child labor is because child labor can interfere with children's education or can be harmful to their healthy and physical, mental, spiritual, moral, social development. So in that sense, international child rights law sees child labor as something dangerous for what? For children's development. Again, re-emphasizing the significance of protecting child development and international law by international child rights law. And the reason for that is because of this embedded image of the child as a developing human being. What we don't see in this reading of the convention is any attention giving to children's living at the present while they are transitioning, right? And if we try to draw comparison between the right to development of children and how the right to development is understood in general international law, and I've mentioned the 1986 declaration earlier, we saw the general international human rights law draw a distinction between the objective of development and the process of development. And I think that this is a very useful distinction that we can draw in our context, and to start thinking about what it means to look at the process of development rather only on its outcome, as the text of the convention does, and in turn, what it might say about the image of the child under international children's rights law. And we can do the same intellectual exercise from a different perspective. We can rethink the image of the child under international child rights law and introduce different understanding of the child and of childhood, and then ask ourselves what this will do to the ways in which we understand and interpret the right to development of children. But before we do that, maybe Anne will have something to say about this image of the child that international child rights law seems to embrace and to project.
Anne, the floor is yours.
Hello, everybody. Thank you very much, Noam, for a really fantastic introduction to your presentation, and of course, capturing many of the really very rich ideas in your book. I did want to just take a moment to reflect on the significance of some of the analysis that Noam has just shared with you from my perspective as a family lawyer. So this idea that this analysis of the international law and the image of the child under international law across the different articles, bringing out the various different domains, really does allow us to see how a juxtaposition of a child as becoming and a child as being, or probably more, and either way, that the problem with that binary being that still the adult is the standard in relation to determining what are good decisions under either model. So where you might have I suppose perhaps the historically earlier focus on a child as becoming, but still present to some extent in its implementation at international law and in fact under the Family Law Act. This idea that children are mini adults. They are, we protect them and we exercise and pass laws that look after their welfare so that they can reach maturity. And at that point, then they can make decisions for themselves. Obviously, that has a very paternalistic, focus to it. And of course, it completely misses, as Noam's mentioned, the agency of children and the importance that the actual process of development plays in all that picture. But equally, Noam's analysis does talk about also the problems with even seeing children as, seeing them as people who we are still protecting or seeing their development as something with an outcome in mind. So yes, we can acknowledge the importance of education, of health, of their emotional and mental capacities or capabilities. But again, it's in order to, there's a hidden standard there in some ways. It's still the adult that's determining what's going to be helpful for the child at that point in time. There's really not much consideration in the sort of the general discourse about what Noam has very clearly identified as development as a process, as something that that enhances where a child's agency and independence is central to understanding what development even means. So we can see this in operation actually, and maybe this might be something we pick on up in more detail later, but in connection with application of various sections and parenting orders in the Family Law Act, this is something that comes up often in relation to understanding what it means to take on board a child's views. This idea of, well, what is not just what their wishes that they express, but do they reflect a maturity? The weighting that's given to them is connected with the maturity and their ability to make the decision in the first place, without considering the importance of being able to make decisions at all. And that's been a real contention in scholarly literature and writing, and equally just the role of some of the other principles and objects underlying the Act in section 60, capital B, if you want to have a look at it. I mean, there it mentions development, but again, it's couched in a lot of other language that actually suggests what gets picked up on and then interpreted and applied is more along the lines of either children as becoming, or this kind of idea that, well, we can protect their capabilities now, but it's because they will become an adult one day. I hope that I've captured at least some of what Noam was saying somewhat accurately, but certainly that's my takeaway message and why I think it's so important that Noam's here today sharing his research with us. I'll back over to you.
Thank you, Anne, for that. It's really, I think, really interesting. And when you read the Family Law Act, I think you can see how the Act itself is torn between these two images of the child. And when you look at parenting matters and the framework that the Act provides, and I'm sorry if I'm going to talk too much family law here. Anne is just finishing teaching the course. I finished teaching the course here last week. So it's all about family law these days. The Family Law Act, in the way, the framework it provides to resolve disputes between adults, between parents when they separate, right? So we need to make decisions about who the child is going to live with and how much time he or she are going to spend with the other parents, and about their decision-making capacities with respect to their own children. The Act is torn between they need to ensure their future the best that we can, and to provide a living arrangement that will secure their present, but not for the sake of securing the present, but for the sake of ensuring that we are not undermining their future. And it seems that when judges are forced to make a decision between two competing suggestions or parenting plans that parents put forward, they are inclined, and to some extent are asked or expected by the Act to prefer the one that seems to ensure the better outcome for children. Ignoring to an extent how the living arrangement might affect children's life at the present, and let alone what their views are. Section 60 CC of the Act doesn't say, it gives children the opportunity to participate in those decisions, but it's not compulsory by any way, by any mean. It's one of a dozen secondary consideration that the law stipulates that judges can take into account if they want. And practice shows that very few judges listen to children directly, and a bit more of them listen to children indirectly if their views are being brought to the court by either an ICL, independent child lawyer, or through a family consultant. Going back to the International Child Rights Law framework, the framework there is different. And the framework there about who the child is and how the child what we should do with the child right to development is, I think, is slightly different than the ways in which it's being done domestically in our family, in the context of our family law system. And I wonder whether these two systems can marry each other, or in different terms, whether our family law system can change in order to be better address Australians' obligations under the convention. As I mentioned, Australia signed and ratified the convention. Children in Australia can expect that their rights under international human rights law will be protected, especially in this very significant time of their life when their parents separate. It's a troubling time anyway for most children. The event in and of itself can affect their development. For some children, it's the best thing that happened to them during their life when their parents are finally separating. But nonetheless, some support is required. And if so, if it's a positive event for children's life, then we should ask ourselves why, and then how we can further support their development. But let's move back for a second to say a few more words about international law before we maybe go back to the domestic domain. So let's ask those questions. If we can rethink about who the child is and what childhood means, then we need to think about in more specific terms what child development means, and what child development means or should mean in the context of interpreting and understanding and implementing a human rights document. And what does it mean then to have a right to development? And we can say a few words, if you would like, about how the UN Committee on the Rights of the Child, the body which is tasked with monitoring the implementation of the convention, had to say about the right to development over the years, in over 30 years of operation, how we can measure development, and what the implication of having a right to development as a separate right of children. If there is any merit to Article 6.2 at the end of the day, comparing to addressing all the other specific rights that the convention mentions, development and protect development, or in other words, whether Article 6 is only the summary of other rights, or whether it has any distinct value in and of itself, which is different than the other domain article that speaks about specific domains of child development. And child development has different understanding. Child development, especially in the legal context, is a standardized child, is a very scientific child. And different professions, not lawyers, but other professions like pediatricians and psychologists and social workers and teachers have their own disciplinary specific understanding of what child development is, how to conceive and understand and to measure child development. And some of those charts are examples to how scientific this body of knowledge, this non-homogeneous body of knowledge is. So we have a chart here that tries to measure the juxtaposition children's height and weight against their age. And then, as every parent in the room might know, then when you have a newborn, they will he or she will be measured, and then the nurse will tell you whether your child is lagging behind their expected development or not. And then you're either freaking out, or you're very proud, or you are satisfied. But nonetheless, your child is based or measured against a standardized child. And then it tells you something about your own parenting and about what you should be doing with them in terms of feeding and caring for their physical development. But it doesn't tell you much, this chart at least doesn't tell you much about their moral development or psychological development or intellectual development. That's will be subject to different charts, like the one we see in the middle, where they tell you when the child should start crawling and walking and playing, and when they should go to school, and other means to quantify child development. So different disciplines use this terminology of child development, but all of them have completely different understanding of what it might mean. So a psychologist will have one specific understanding of what child development is, comparing it to a pediatrician. And the two will look at the same child, but will see completely different things. And these two bodies of knowledge, these scientific bodies of knowledge, are not homogeneous as well. So different psychologists will quantify and will measure child development in different terms, and they might have disagreements between them as to where the child is, comparing to where the child should be, and how the child should best supported to mitigate previous traumas or any emotional difficulties that he or she might have, or to cope with life events. We spoke about parental separation. This is usually when children, those who can afford it, are receiving some external help. But none of those discourses are featured or being mentioned explicitly by the convention, or for that matter by domestic legislation, and they are not something that we as lawyers, and I'm saying we because most of the people in the room are lawyers, can cope with. I'm standing in my office here. We don't teach child development in this building. So I'm teaching family law and I'm teaching international child rights law, but we don't teach what child development is. My students don't know what it is. Those who go and practice human rights law don't necessarily know what child development is. But nonetheless, usually it's lawyers who are tasked with implementing international human rights law standards or developing local policies and local legislation that should put some flesh on the bone here. But we don't really know what to do with child development. So one of the main tasks, I think, in concretizing the obligations that the convention gives rise to in general, and that Article 6.2 give rise to more specifically, is to have this conversation between disciplines, because lawyers are by no means the best people to interpret what Article 6.2 might mean and how it should look from the point of view of children. So we must reach out to other disciplines who have the disciplinary specific knowledge and can tell us something about what child development might mean. And lawyers should do that with their realization, with some modesty, something that most lawyers don't have, but with the understanding that we don't have that knowledge. And we must reach out to other disciplines with a pinch of salt, because all those are scientific bodies of knowledge that are not free from their own disciplinary biases in general, and biases against parents and against specific groups of children. Those who are at the margin, groups of children who are being marginalized, or discriminated based on their gender or socioeconomic status, or their parents' socioeconomic status, or their migration status. Those disciplines have been weaponized in the past to target them. Child development, for example, going back to family law example, has been used in the 80s in order to vilify single parents and single motherhoods, suggesting that children should not be raised by single moms because that will undermine their development. This will be harmful for the child. The same discourse was then used in the 90s and 2000, and even today against LGBTQI parents, suggesting that they should not be able to adopt children or to raise children in any other way, or to acknowledge their parenting because it will be harmful for children. So some people try to disguise or to hide their homophobia and instead using child best interest or child rights discourse to justify their homophobic position. So going back to international child rights law, when we need to acknowledge that we as lawyers don't have sufficient knowledge about what child development is, which I think is a precondition to implement this document. But then when we reach out to other disciplines, we should, again, as I said, do it with some cautious. And as Emily Bass from University of Chicago, I've said, who looked into the intersection between law and child development extensively over the years, she has suggested that law should remain in the driver's seat. So we should implement this legal document, this human rights document, from within its own spirit and its own objective, while incorporating and making use of others' bodies of knowledge that help us understand specific terms that the convention uses. Because the convention uses child development, this term child development, time and again. But when you read the drafting process of the convention, and I spent a lot of time reading 10 years of drafting, you could see that the drafters didn't say anything about what child development might mean. Not least because, that's one of my arguments, is that because it's so intuitively to think about children in terms of development. Erica Berman from University of Manchester said, we can't undo development when we think about children. That's almost the natural thing to do. But it subjugates children to their future selves, and we should break down that dichotomy. And as Anne was saying, we shouldn't measure children against adults. And this is one of the moves that I think we should do if we would like to embrace the human being approach to children, to recognize the importance of childhood as an important time of human beings' life, and the significance, and give respect to children, human dignity and human agency in the course of protecting their own development. It starts with acknowledging that development is something that children do, but it's not the only thing that defines them. They grow up, all of us grow up. But from international human rights law perspective, we, as I said, once we reach the age of 18, we are no longer developing. We know that we are changing, we are learning, our capabilities are in decline at some point, but the image is that we are a static human being until we die. For children, it's a completely different story. But the change that we should adopt, I think, is look at children on their being and their becoming, but we should go even further. We should drop this duality. We should not measure children in these binary terms of either here and now or the future. Children's lives and temporality are much more complex than that. Children grow up, but they also live in the present, and they do these two things simultaneously in a much more composite and complex way. And we can even make this argument even more complicated. When we think about children's future, we should think about futures during their own childhood. Future is not only when you turn 18. From children's perspective, the future is next year or next month. For younger children, there is a future of 10 or 15 or 17 years before they turn 18 and become adults. For other children, usually in the adolescence years, the future is much more tangible. You're waiting before you can get before you go to high school. You're waiting for when you become 16, so you can get your driving license and have some more independency. Different events in children's life, heavily regulated by law, represents different futures for children. In that sense, when we think about their development, we should also account for different developmental milestones that children have and enjoy during their childhood. In other words, we think about the process and we think about the outcome. The outcome is much more complex than just turning an adult at the age of 18. And childhood and the image of the child should reflect that. And I think it can start giving us some more complex understanding of what having the right to development might mean. But I wonder if Anne would like to jump in again, or should I continue to run for a few more minutes?
I think keep going. It's so interesting.
I was hoping to get a break. Sorry.
No. Oh, okay. Well, please grab a drink. I mean, I guess I would just say that I think that's a really interesting way of rethinking childhood. I really like that move about seeing children both in the present and growing up at the same time. And seeing and understanding what we mean by our children's futures as being within the period of childhood too. I think that creates a shift away from both thinking about a standard child, but also, or a standardized child, but also thinking about that, well, you know, what a kind of a fixed view that at the end of that standardized childhood, they will be an adult. And that's when I guess the assumption is that they will have value, which of course I don't agree with, and I don't think is true. And I think that's not the message of the Convention on the Rights of the Child, or in fact, the purpose of what many of these individuals are doing. But I don't think that's necessarily being communicated very clearly, either in the language of the document or it's more so in its implementation. So I think reviewing and going back to this idea of right development, what does it mean? The interdisciplinary approach, I think, is really valuable because, yes, on this, and as a person who's involved in family law, I understood so much more about what it might achieve. Well, once I had children of my own, to be quite honest, and there was a way of being with children around the passage of time even that I wasn't aware of. So previously I might have said so to a child, you know, oh, so what'd you do yesterday? I mean, sometimes a child is too doesn't actually, yesterday? It's a very conceptual thing, or next year or last year, like what? But I see you finished your drink, so I'll leave you to, hand you back to the expert.
I have some more sips here. Okay, sorry. No, I think you're absolutely right. I mean, I think that's a good segue for another point that I would like to make, which is about child participation and how marrying Article 12 and Article 6, what will be the meaning of marrying Article 12 and Article 6? Article 12, the Convention speaks about the child rights to participate, more specifically about the child rights to participate in decision concerning her life, which is often seen as the embodiment of the human being understanding of childhood in the Convention. Is the article that gives children a seat at the table. It's the article that respects their agency. and for the first time enabling children to take ownership and be part of defining their own childhood and their future adulthood. And to some extent, some commentators have suggested that we can like strip all the convention articles but one, Article 12. And if we only have Article 12 and the right to participation, it will make the major change in children's life, moving them from being subject to objects, from being to being seen and to be treated as right holders. And when you review, and I will maybe finish with that idea before opening the floor, when you review what the Committee on the Rights of the Child have said about the right to development in 25, and the child development in 25 years of operation, you could see that it linked the need to protect child development to almost each and every right of the convention, going beyond those 5 articles that I've mentioned earlier today. Any domain of child life, being education, health, early childhood development, children in street situation, parental separation, refugee children, just name it, it was linked by the committee in one way or the other to the need to protect child development. And they did it with respect to every article in the convention, but Article 12. They were just unable to conceive the active child in the course of protecting children's development, which reaffirms this passive nature of which children are being seen as these vulnerable human beings that requires protection in the journey of their adulthood. You see a change, some change with that respect in the committee's work in the last few years, corresponding with a broader change in the committee's attitude toward children seeing rights as an empowering tool. And I'll end with that point. When you think about different understanding of what human development is, and we specifically look at what Amartya Sen and Martha Nussbaum said about the meaning of human development, Sen's famous book is Development as Freedom. They see development as a means to emancipate people as individuals and as collective. And if you take this understanding of human development and you use that to read the convention, to use child development, you can start thinking about the right to development in Article 6 as this emancipatory right, where children can be emancipated and take ownership over the course of their own childhood as a journey, in a significant in of itself, and when defining the outcome of it, whether this outcome occurs during their childhood or when they finally transform and become adults. And this is where Article 12 and the right to participation becomes even more important. Children should be able, under the convention, to define and to participate in defining and protecting their own right to development. Article 6, Article 12 are part of the 2 guiding principles of the convention. In that sense, as the Committee on the Rights of the Child itself defined in 2005, these are 2 of the 4 most important articles of the convention. One cannot implement the convention without paying attention and protect these 2 rights, and the linkage between these 2 is imperative. I'll stop here. Tina asked me to shut up.
I did not. I asked you to, that's a lie. I asked perhaps that, Anne, if you have any comments before I open the floor for questions from the audience.
My only point was that I really like the idea of the ways that this analysis leads to an independent right of development. So children are the rights bearers of the right to development, rather than that being something that often, and you can see it in the Convention on the Rights of the Child, but also in the Family Law Act, how often that right becomes something that the parents have to enable, support, protect, and so it becomes filtered through parents and other adults' needs. And I really like that personally. I think that was a really interesting change and a shift. But looking at the time and making sure we've got opportunities for lots of questions, back to you, Dina. I do have some, but please prioritise the others who might not have had anything to say yet.
Of course, and I'm hoping we will have a little bit of time at the end. So far, I have one question from the audience. It's from Isabel, who's asking, she's interested to understand the projected image of the child in the CRC, given the huge difference between children's experience, and what she has in mind in particular is gendered experience between gender rights violation and children development risks for boys and girls, respectively. So Noam, the floor is yours.
Thank you. That's a very interesting question, because the convention doesn't do a good job with that respect at all. Gender is not mentioned in the convention. When you look at Article 2 and the right to non-discrimination, you see that it lists, like, I think 11 grounds for non-discrimination. You find sex, you don't find gender. The convention was drafted during the 1980s. It's a product of the 80s. It's bad hair, bad music, but also gender wasn't part of their vocabulary there. They speak about sex discrimination, you don't speak about gender discrimination. It has been argued by Philip Virman and Michael Freeman and others that in that sense the convention is outdated. It lacks a number of gender-specific language, like gender in of itself. It doesn't speak about LGBTQI plus children. Again, this vocabulary just wasn't on the horizon during the 80s, and it doesn't do a good job in looking on intersections of identities. If we move beyond the boy girl, the child girl, and the convention doesn't account or doesn't do sufficient job in accounting of different living experiences of boys and girls in different cultures, and the ways in which the gender roles that they ascribe to children. Over the years, there were some local variations and local, either domestic context or regional contexts, where some understanding of the need to differentiate between how we protect and conceive, how we conceive boys and girls, and therefore how we conceive and protect the rights of boys and girls in different ways have been developed. The adoption of the African charters on the rights and welfare of the child was quite helpful in that front, developing a local African understanding of child rights, but also in other regions. But you can see how this the convention is a universal document. On the one hand, that suggests that we should celebrate it because it's relevant for every country in the world, but it's very much Eurocentric document, which represents Eurocentric understanding of family structures and of gender dynamics and of gender roles. The image of the family that it projects and builds upon is this nuclear model of mom and dad and 2.4 children with very specific course of childhood that you would like. The convention tells us a very convincing middle-class European story about childhood that ignores gender experiences. So a child should be cared for during the early years. It has the right to survival. That's the first element of Article 6.2. And then the child should go to school. And Article 28 suggests that primary school is compulsory, ignoring experiences of children where they can't go to school for different reasons, because the parents can't afford it, because they help with support the family economically, or be domestic workers. We might think that it's inappropriate that children should go to school, but we ignore cultures where it is deemed to be appropriate, or that children won't go to school, or that girl will stay home. And maybe international human rights law have something to say about that. Plural approaches will suggest it shouldn't. But nonetheless, children should go to school, and primary school is compulsory. And then Article 31 tells us that children have the right to play and leisure. So it's not only about going to school in the morning, but also about having time to play with your friends and peers at the afternoon, and to enjoy cultural events and so on and so forth. This is a very middle-class, upper middle-class experience of childhood. Very few children go to the playground in the afternoon or sit with their Nintendo or iPad in the afternoon. That's a very luxurious childhood. But that's what the convention images. And that's sorts of rights that it therefore acknowledges for children. It doesn't do a really good job in that sense in being inclusive for different cultures and different manifestations of childhood. And it's an embodiment of this tension between universal, i.e. Western Eurocentric norms, and local cultures. The campaign against, for example, child brides is a good example for that, and I will end my answers with that. There was a huge campaign 10 years ago against early marriage, where girls at the age of 8, 9, or 10 their pictures were taken and splashed over social media. I think it was in Saudi Arabia, where there were like huge marriage where girls at the age of 8, 9, or 10 were married to older to older guys. I think it was by Plan International and other NGOs. But then it was revealed that it was an orchestrated picture and so on and so forth. But the point is, and that's research that comes out in recent years, where early marriage with all the harm that it causes for children. Also, when you talk about girls who got married before they turned 18, they speak about this, how it protected them, it enabled them to be fed, it didn't necessarily undermine their education, and they were enjoying it, or in other words, characterize this experience in more positive terms comparing to what Western NGOs have said. We can criticize, I think, both issues. I think that both those polarized views are insufficiently nuanced. But the point is that the convention portrays this universal image of the child, but nonetheless, it's very much embedded in very confined, specific, class-specific, gender-specific understanding of who the child is and what childhood should be.
Thank you. Thank you very much, Noam. I think that was a very wide-reaching answer. Any other questions from our audience? I haven't received any other questions for the time being, so I'll just make a very small comment abusing my chair privileges, and then I'll return it to Anne. What was really, really interesting to me in your initial presentation was the way it finally made some things from my own research made sense, which is how often in openly colonial discourses of international law, non-white, non-Western peoples are literally infantilized, right? Sometimes in older times and until the League of Nations especially, very literally referred to as children. And it was always kind of self-evident to me why literally infantilizing people is like a bad thing to be doing. But only now it started making sense, also in the context of this devaluing of childhood in its own right, and only being as valued as something that prepares you for adulthood, right? So this sort of like evolutionist understanding, which seems to be present, of course, in the CRC, but it was also so present, especially in the more humanitarian versions of colonialism that the League was so good at doing, right? So now that you talked about how children were viewed by the League of Nations, a lot of things about the colonial bits of the League of Nations suddenly really made sense to me. Yes, because it was, in my view, it was at the League when suddenly they stopped talking so openly in the register of race, and they started talking about colonialism in the register of childhood. And I was trying to understand where did that come from. And I think this helps me to piece it together, at least partially. I think there's more to be answered. So I just wanted to say what an unexpected
turn of events. Thank you. No, that I'm pleased that you found it useful and helpful, because I think, this notion of infantilization is a part of the common language. When you say that someone is immature, irrational, lack of capacity, so you say he's acting like a child. But it tells us more about how we perceive children and how we perceive adults. But children are, and as I was saying beforehand, children should be taken on their own terms. And that's a child rights approach to children. Rather than to be compared to adults and to be seen as adults in deficiencies. Children don't have less than adults, they are different. Carl Gilligan speak about in different voice. We shouldn't compare the two, and we shouldn't juxtaposition children to adults. They are just who they are being children. There is no deficiency in that. They are who they are, and therefore when we think about their rights, we should think about their rights from their own terms, rather than to think about the rights from who they are not. They are not adults. They may be adults in the making, but are not there, and it's fine. They shouldn't be there because they're different. And I was thinking about your research, about your book, and maybe we'll finish with that, when Carl Hansen wrote a very interesting introduction to the latest issue of Childhood. He's a director of the Child Rights Center in Geneva, and Carl was saying that children in that sense represents the future. But they're also this image of the child is also embedded in this Western idea of modernity, and modernity and capitalism, going back to your book, which portrays some cultures and some families as backwards, as if they belong to the past. And then we have this tension, which seems to go to the heart of modernity, which is how we compromise or settle the central place that children plays in modernity, preoccupation with the future, and what it might say about the need to reinvent and to rethink about child rights in the context of modernity itself, because the children are the future, but some societies are backwards, they are not modern, and their parents are not modern enough. So what will that say about children and how families play a role and children play a role as future members of the capitalist society? Because when you look, for example, and I will end with that, with some ways in which especially US cases look at child development in the context of family law, they talk about the need to ensure that children will become productive citizens. So the end game is not about becoming an adult or enable children to develop their fullest potential, as Article 27 suggests, but rather is how we make sure that they become productive members of society. That's what they should be doing. That's their goal in life, to keep the machine going.
That is a wonderful way to end. There is one more question, but I don't want you to have to go over time. So I will give my apologies to Roslane, and I will wrap things up. Thank you, both of you, very, very much for your time and your generosity, especially on a Friday, and especially quite late in the teaching term for all of us. Thank you to those who attended. We also value your time. And if you're interested, I think the next seminar of the series will be in August. Thank you very much and hope to see you all soon.